In this presentation, I'm going to give you what would be considered kind of part one of part two. So kind of after you are done writing your first thought paper, I want you to start now thinking about the legal system and courts as a form of conflict resolution. And specifically, I want you to think about it in the sense of an attempt at conflict resolution. And we want to think about this from both the structure of the court and also the history of the court. And to start thinking about this as custom or habits and routines that a particular group of people hold. So I almost want to add the word tribal here. And I think the picture behind it shows, right? So when they're, on the one hand, you could think about the police as a tribe, a group of people who share a common cause, a common ideology, and in many ways, right, share economic resources. On the other hand, you see these angry protesters as a tribe that is saying, we don't want to follow your tribe's rules. So they have two very different ideas about what the rules are and what the rules should be. And so we see there's a conflict. So how to resolve this conflict is going to be less clear. So I might start with the stereotype of what we imagine a courtroom to look like. And here I would compare it to, say, a religious institution almost, right? You can almost hear the beautiful singing and, you know, birds are coming and chirping and everybody's getting along and everything's wonderful and it's all very well organized and everybody's well behaved. And certainly this is, at least on the TV shows and movies that I've seen, this is the image that is portrayed to most people. So if you have never been in a courtroom, you'd start to believe this. However, in reality, this is a more common scene in a courtroom. And I don't mean to say that this is always the case. Certainly there are situations in which people are more or less well behaved. But the point here is to remember, these are people who are very angry with each other. They're coming in almost like two children who have been fighting for a long time, and now someone has to resolve the conflict between them. And they also come from very specific groups, right? So they have family members, they have friends, they might be affiliated with a gang, they might be affiliated with a neighborhood, they might be affiliated with the police department, right? So they have social groups who are also very angry with other groups. So I just want to kind of kill the myth that, you know, the courtroom is some kind of magical place that has a spiritual connection that when people walk in, suddenly everybody's well behaved. Having gone to the courtroom, you know, a fair number of times, I've seen behavior like this probably, you know, 10 to 15 times. So the overwhelming majority of the time, it's not like this. But it's also not serene and quiet like the other picture. So most of the time, the courtroom is kind of in between, right? People might be arguing, but they're not brawling. They might be very impolite with each other and talking very rudely to one another, but they haven't reached the level of physical assault. And I think this is the kind of idea that I want you to think about. So when we think about the politics of rights, you're reading, and specifically chapter 12, what Dr. Stuart Scheingold is trying to show here, he was a lawyer and a PhD, a legal scholar, you know, he was trying to show that the expectations of rights and this particular idea in America that kind of gives like the myth that you have individual rights that are based on a meritocracy. In other words, you will be individually protected if you just follow the rules and you do a good job and you work hard. This is a story we all hear, even in college. But as Scheingold shows, it's just fundamentally not true. It's more complicated than that, in other words. And he says, you know, there's multiple levels of this if you read the whole book. The expectations are different among judges than they are among practicing lawyers. The expectations are different among legal theorists and legal scholars than it is among practicing lawyers. And then that's widely different than what ordinary folk believe about the judicial system and their rights. So specific examples I want to pull from chapter 12 are here. So if we're thinking about a transformation or change, social change, then what we have to understand is that as a rule, you need a transformation of the entire culture. You need a cultural shift, right? So the abolition of slavery, or at least one form of slavery, the slavery that was prominent in the Atlantic slave trade in the 1860s, had to come out through a civil war and through a cultural change. It didn't just come out because Congress had declared through the 13th Amendment that it was no longer legal except for as a form of punishment. And by the way, it was no longer legal in the sense that if you were enslaved, you now had the ability to go to court to fight for your case. This did not mean that suddenly all the slave owners said, oh, okay, so the Congress has decided that what I'm doing is illegal, so I'm going to forget all the money I'm going to make, and I'm suddenly going to follow the law. In fact, we know from studying history that most people did not follow the law. And then the second idea here is that, the legal change, again, gave certain people the right to get an attorney and try to fight on behalf of their case, but it didn't change the slave practices in the rest of the world. So while a small number of people were able to take advantage of this case, you'll see that by and large it didn't transform the culture, and which explains why we're still in the difficulty we're in now. But if you take this idea that if you're really interested in social change at the fundamental level, meaning a complete and utter change, there are examples in human history that we can look at, the scientific revolution being one of them, and also the ethics revolution that happened around 2,500 years ago. And so we want to think about it in the sense that you need to transform the culture in that same way. And it's possible, of course. And one promising avenue could be the application of physics education and having a more material understanding of what quote-unquote good behavior and bad behavior would be. But again, that would have to be a massive shift in entertainment, in our cultural outlets, in our education system, and in our legal system. So then the case that we're looking at here is, it must be conceded, it must be admitted that legal tactics alone, or even in connection with some form of political mobilization, hold little or no promise of fundamental change. And I want to be careful here. It is not. He's not saying in this book, if you read the rest of the book, he's not saying that it has no value. So let me give you an example on a case that I'm working on involving the defund police movement and the refunding of education, state services, and social services, and Black Lives Matter. The push for legislative change in that arena, through protesting and through advocacy to city councils, to states, and to the federal government, to a very limited extent to the federal government, is not going to make a fundamental change in the way that people of color are treated by most white people in America. It will, however, have a change, what's called a marginal change in political science, towards people like the police or the city council, and in some cases, some businesses. So the change that BLM is going for is not necessarily fundamental cultural change. They're not naive. They don't believe that 300 years of white supremacy is going to suddenly vanish and white people are suddenly going to start seeing people and treating people as equals and giving up some of their benefits. So the legal tactics are not intended to make that kind of radical change. There's other things that you'd have to do. Like I said, education is one promising aspect. So legal tactics and political mobilization have very specific goals in mind. And if you get in deep and you listen to the organizers of that movement and not all the social media nonsense, you'll hear that that's what they're aiming for. They're aiming for very particular things, not this big, wide kind of naive idea. So this leads, Scheingold, who's studying this in the 70s after the Civil Rights Movement, to say this, to make liberalism a reality. In other words, to make this liberal ideal that the West, England, France, the United States, and to some extent Germany have kind of put forward as this goal of having a democratic, participatory kind of based system of justice, would have to be, first and foremost, to preserve and extend the historical achievements over the last 1,000 years that kind of defines what Western liberalism is. So the first being civil liberties, the second being protection against arbitrary authority, and a considerable degree of participation in the political process by those whom the process affects. So, we are far from that ideal. And I could go through each of these. Civil liberties were destroyed by the Patriot Act in exchange for a fantasy of security. Protection against arbitrary authority has been destroyed mostly by just passive acceptance. The people are just letting people arbitrarily do things against them and have a great number of excuses for why they don't act. And then, the political process has been so politicized over the last 30 years that it has done an excellent job, a very productive job of excluding people from participating. And so we're further away from liberalism as a reality than we've probably ever been, with maybe a couple exceptions of, say, like the Jim Crow era and slavery at its peak. I think, and even then there were people who were fighting more than they're fighting today as far as advocacy. So there's this kind of sense that Scheingold's, trying to build here is that the conclusion is that, if the goal is transformation of culture, then the case of legal tactics is not going to be the solution. That's a limited and a marginal form of change. So in conclusion, if you really want to make democratic participation a reality, it's going to have to happen outside of the legal arena and likely outside of the current political structure. So let's unpack some of the current beliefs, and I call these the dragons that I often have to try to destroy in the classroom, and here I'll try to do it over this video. So, let's just start with the obvious. We see three people who pretend to hate each other on social media and on the news, quote unquote news, who in this picture seem to be just, perfectly fine friends. And that's part of this political theater, is that these folks are friends behind the scenes. But when they get up in front of us all, suddenly they pretend like they're, we're actually really against each other. So I'm just going to go, pick on all three of these people at the same time so that nobody can call me unfairly biased. All three of these individuals have said disobedience must be punished severely to ensure law and order. And each of these people have violated their own rule over and over and over again, but I'll pick on President Trump because he's in office now. So Trump has refused to comply with tax codes, which you and I, if we did that, and Wesley Snipes would be a great example, would be in jail. But he is not. Trump's violated the separation of power doctrine on numerous occasions and has explicitly admitted it, that he doesn't really care. Now, in his defense, Harry Truman did it, Abraham Lincoln did it, Thomas Jefferson did it. However, right, it's still a violation of the rule of disobedience must be punished severely to ensure law and order. And then Trump's illegal acceptance of money and the emolument in the violation of Article 2 of the United States Constitution is shocking to legal scholars and most lawyers and judges. Shocking in the sense that ordinary folks don't seem to either understand that what he's doing is illegal or they don't care. And so his acceptance of corporate donations from Saudi Arabian firms, his acceptance of hotel deals all around the world, and again, linking back to his tax situation, is a clear violation of Article 2 of the United States, in which he actually admitted, both in the Biden debate and in the Clinton debate 4 years ago, and his excuse was simply, hey, everybody's doing it, so you can't blame me. You guys are the ones who made these rules. But again, remember, he then on the same hour has the audacity to say, but listen, I'm for law and order. So in other words, he's for law and order for everyone but him and his friends. And so Trump's admitted sexual assault, I think, is probably, in my opinion, the most egregious because he's caught on tape admitting that he committed a crime. Again, if you and I were ever to say something like that and somebody had recorded us doing that, we'd very likely be in jail, if not at least arrested. And now I hear somebody's out there in the world saying, but no, he's got an excuse. Okay, fine. I will accept that idea. I think I know law pretty well. I've been studying it for a long time. Ignorance of the law is no excuse, but here we go. Let's pretend that the current belief system that you all are a part of, and you all being ordinary folks, non-lawyers, is that law and order must be maintained unless you have an excuse in your defense. So if you have an excuse, then forget law and order. It's no big deal. We don't need to follow the rules. We can be as disobedient as I want as long as we have an excuse. And so, okay, fine. So rights in courts are not about establishing moral truths nor ideals of liberal democracy in that sense. So all they're really for then in 2020, according to ordinary folks, is they're there to resolve petty disputes among common folks and not elites. So in other words, it's not for Donald Trump, it's not for the Clintons, it's not for Bill Gates, not for Warren Buffett, it's not for Jay-Z, right? It's not for Beyonce. It is for just regular folks and their little tiny, differences of opinion. So, they say, well, I think my fence line is supposed to be here, and so we go to court. I think I'm supposed to get $20,000 instead of $18,000, so we go to court. You touched me inappropriately in the subway, so let's go to court. Now, I'm not saying that these things aren't right or wrong. I'm just saying this seems to be what ordinary folks, and especially if I watch, CSI and those kind of shows, this seems to be what ordinary folks want the legal system to be. So this is the opposite of what Article 3 of the United States Constitution set the legal system to be. So I think, the points here that I've bolded and underlined it is like, look, the judicial power is in one Supreme Court. So it shouldn't be, according to the U.S. Constitution, an opinion-based legal system. In other words, I hate to say it this way, but this is the only way I can say it. According to the United States Constitution, it doesn't matter what you think the legal system should be. It is not up for a public opinion poll. It's not for debate. It's not for a vote. It's up to the Supreme Court to decide what the judicial powers are, period. And there I could be quoting Chief Justice John Marshall. It is up to the Supreme Court to interpret the Constitution, not Donald Trump, not Hillary Clinton, not Governor Cuomo, and certainly nobody on the news, quote-unquote news channels. So there's also this idea of inferior courts by Congress. So Congress can set up these kind of separate courts, separate from the Supreme Court. But again, the judicial power rests with the Supreme Court. So these inferior courts must report up to the Supreme Court and follow their lead. So, okay, how does this work? What the historical and structural point of this is that there was two sources of law, and I'm hoping you're getting this in your readings that you're doing. And again, it's usually easier to talk about it in class, so I'm doing my best here, and if you have questions, please do contact me so we can talk about it further. But basically, the thing that I think most students are not aware of is this idea about equity and the historical basis of that. And this is what we call the common law, and this is what Blackstone was making commentaries on and about. In other words, I think you all are used to the idea that law or laws are the things that you see written down, say, in the subway, right? Where it says no spitting, don't cross between the cars, or you see something like, don't speed, or these kind of thou shall nots, right? Do not do these things. And you accept those as laws. And sure, that's one form of law, and we call it either positive law or legislative law. And this is what they mean, to all cases in law. So those are accepted, we understand that, and the court is going to interpret what those laws mean and apply them to everyday situations. However, the vast majority of the law, so in other words, 85 to 90% of the laws are not based in legislation. They're based in equity. They're based in common law. And these things are, what some people would call counterintuitive, meaning they kind of hurt your brain when you think about it. And usually in court, or in class, I usually do it this way. How many of you, and there's 40-something people in the class, I say, how many of you believe that it is the law that if there's someone drowning in the ocean outside of Kingsborough, that you must throw off your book bag, run into the water like Baywatch, dive in, save the person, etc. And there's usually great conversations about Good Samaritan laws. There's all these interesting, should the person do this? Should they do that? What happens if this happens? But the ultimate result is that according to equity, according to the common law, according to judges in the United States of America, the answer is no. You do not have a duty to go rescue someone who's drowning, unless you are a lifeguard, a certified lifeguard on duty. So that doesn't apply to lifeguards who are off duty. A certified police officer, and it is your duty to save them. In other words, you're not helping someone else, or you're not, solving a crime. Or a firefighter, and that one's vague. A firefighter may or may not have to go save the person. So, that surprises a lot of people because they say, wait, but the legislation says this. Okay, but the court, right? Remember, the judicial power is established in the Supreme Court, and the Supreme Court has already spoken on this. So it's kind of irrelevant what the majority of people in some state believe should happen. It's up to the Supreme Court. And so I think that's, hard for students to understand, but there's a history there that goes back to England establishing the courts of equity. And so oftentimes, the way I'll explain this is that oftentimes, starting in the 1200s, if you can believe it, in England, the then Parliament, the small group of people who made the laws for the king, would pass a law trying to say something like, if your sheep goes into your neighbor's property, and of course these are like hundreds of miles away, right? But your sheep goes into another neighbor's property, it becomes their sheep unless you had some kind of offense, right? An offense in 1200 would be like a bunch of rocks stacked up. And so that would be the rule, right? But what about a situation, right, where the sheep went through a river, right? And you're not allowed, according to the king's law, to put a fence around a river. So who gets to decide there? So these courts of equity would be in what was called the king's court. So literally you'd go to the kingdom, you'd go into the castle, and everybody would gather. And the king would be there sometimes and sometimes wouldn't be there. But a group of his closest advisors, what would later become judges, would try to think about this particular case. Later on, the king, got smart. He was kind of busy and didn't want to deal with all this all the time. Would send those folks out into the country. And so then these judges, this is like the early judges, would start to solve these cases, and they were called courts of equity, right? And this is how the common law has been established, meaning this is the law that is common to all folks, and not just these particular instances that Parliament or legislation or Congress has passed. So that's the history of it. So now we want to think about this in the sense of crimes. So the Constitution says very explicitly that the trial of all crimes, except in cases of impeachment, shall be by jury. So if I were Donald Trump, and I assume that I'm going to live after, let's say I win another election in 8 years, in the 9th year, right? So let's see, what is that? It's going to be 2025. He is going to be tried for his crimes. And people say, okay, but I thought he was found not guilty by impeachment. Correct, right? Because it says the trial of all crimes except in cases of impeachment shall be by jury. So he went through his impeachment process just like Bill Clinton did, just like other presidents have gone through. But he hasn't gone through a jury criminal trial. And so, this should be the thing that keeps him up at night, if anything does, is that the second he either loses this election or after his 8 years, he's going to be subject to criminal proceedings. Now, granted, he's going to be like 80-something years old, so what does he care? But, the point here is interesting if you start thinking about all the cases that don't go to jury trials. So, in theory, according to Article 3 of the United States Constitution, plea bargains are illegal, and yet they continue. So now we have to get to this idea of, okay, fine, the law is not the law, in other words. And, the Constitution obviously is something that can be interpreted in a lot of different ways, and people want to have law be a part of politics and not just let the Supreme Court make these decisions. So let's again apply this to current day thinking. At least apparently by most ordinary folks. So wrong has been committed from the point of view of the person injured or harmed. In other words, this is not a wrong that has been committed according to your God. This is not a wrong that has been committed according to the Pope. This is not a wrong that has been committed according to what's called objective reasonings. This is, the point of view of the person who is injured or harmed thinks that they were wronged. So they bring this forward. They say, I've been wronged. But the wrong, right, the actual action, is defined by the social group by which the injured harmed person is a member. So let's say you're a Jehovah's Witness and you've been harmed by a violation of your rules according to your religious beliefs. That's the harm. That's how it's defined. It's defined by what's called the reasonable, prudent person standard. And so in that case, you would have your idea of how you were wrong, and you'd bring that forward as your legal claim or your quote-unquote right. But most of the time, the injurer, the harmer, is going to have an excuse. They're saying, well, I didn't know that you were a Jehovah's Witness when I did this to you. Or they'll say, I didn't mean to, it was an accident, right? So now, resolution could come from the social group if they're all Jehovah's Witnesses, or if they're all Muslims, or if they're all Spanish-speaking folks, right? And they're all from the same neighborhood. It could come within that group, and it might be fairly easy to meet justice, because that form of justice would be agreed upon, possibly, right? Maybe not. And there'd be certain rules and expectations of how people are to behave. But what if they're from different social groups? And here I would look at the picture. What if it's a black musician is harmed by the KKK, and it was an intentional harm, but it's from his point of view that he was harmed, but the KKK is going to have an excuse. And so how do we resolve that conflict? Well, we bring in a third party, a judge, right? This is the ideal of Western liberal democracy, that a third party, allegedly neutral, is going to be able to hear the arguments and make a ruling based on common law, based on equity. But as you see in the headline here, this particular individual, Daryl Davis, decided to go outside of the judicial system or avoid it altogether, and he went straight to the KKK. And he has been engaged with a different form of conflict resolution by trying to change their minds and their moral outlook. And so, you see this is called restorative justice for any of you who are interested in this. But, there's a different kind of process in three different situations here. We have one where if you're all from the same group, you probably already have customs that you can resolve the conflict. If it's two different groups, you could go to the legal system, and I'm about to go into what those customs are, or you could go your own way, right? The third option is you could figure out some way of restoring justice outside of the legal system and outside of your cultural group. So the United States, has a very particularly, and I was watching a thing last night with a federal court judge, Lasnik, who I've had the privilege of spending time with, and, he said, we have a particularly interesting legal system in this country, and even though, the country seems to be at odds with each other in its politics, judges and lawyers more or less treat each other with respect. So how is that possible? How are those customs so well maintained is kind of the question. Well, look, at 1776, right, the quote-unquote formation of the country, or the founding, depending on which language you're using, most of the colonists in the 13 colonies had families that had either migrated or had settled in those colonies, English colonies, since the mid-1600s. So that's 100 and something years, right? So you're talking like 5-6 generations of English folks who have built up the economy, they've built trade relations, some of them are killing Indians, others are working with Indians, others have adopted the French, others have fought with the French, right? So you've got this whole kind of like struggle going on for 125 years, but they had a common ancestry and what's called English stock. So in other words, they were from places like England, like especially southwestern England and what's now called Manchester in kind of northwestern England. They were from Wales, and there were some, not many, but some were from northern continental Europe, like Belgium and France. But not until the late 1800s do you start getting waves of immigrants that are not English. So you have 200 and something years where the English traditions are being replicated, being copied here in the United States. And so, a jury of peers at that time would be well-educated, land-owning males of English stock. So they have a common culture. They have customs that they know well, that they teach their children. And so conflict resolution is fairly straightforward. So it would be based on pagan custom and some variations of Christian, although not Catholic, and they're very clear in the writings in the 1770s especially that they are absolutely not Catholic. And it would be an interpretation of the golden rule of something like, do unto others as you would have them done to you, in something more like, what is your main priority? Well, the main priority at this time is liberty, the right to be left alone. And so if you harm me, I'm probably going to forgive you, as opposed to go through some long drawn out process, because really I don't have the time. And it would be better for our community if we kind of all got along. And, again, that's a very pagan interpretation of the Christian experience of the Golden Rule. So, those outside the English stock, however, were not so lucky. So Jews weren't afforded this kind of level of forgiveness. American Indian tribes are famously, right, were subject to genocide and the removal and the replacement and reservations. But also the French, Spanish, and Dutch had to face the fury of war. And the English Americans were quite vicious in their attacks and their approaches to fighting with the French, the Spanish, and the Dutch. And then probably most obvious are enslaved Africans not getting the benefit of those English customs. So, I start with a quote here, "A house divided cannot stand," and this was Abraham Lincoln's point after the Dred Scott case. When you have suddenly, right, white men, as so-called white men, are numerical minority, but they're the power majority. And what does that mean? So, if you look at the Supreme Court, if you look at Congress, if you look at the presidency and his cabinet and the agencies, if you look at Fortune 500 companies, if you look at the richest people in the world, if you look at who owns entertainment companies, not who the performers are, if you look at who owns NFL teams or other sports teams, you'll see by and large, the overwhelming majority of them are white men, even though they're statistically a very small number of humans on the planet. But even smaller are English, quote-unquote, white men. Very tiny, tiny, tiny. So you see the legal system is based on a historical system of English white men, although English white men are very, very small as a population in the United States. And then, some facts, right? There are a majority of women in law schools now over the last 15 years. So when will you start to see that influence on the legal system? I'm not sure. We have a majority Catholic Supreme Court. I just told you that in 1776, you weren't even allowed to come to the United States if you said you were Catholic. So, how will that Catholic experience change the legal system in the United States is hard to say. You have a majority evangelical Christian, not English Christians, but evangelical Christians voters now, right? And we'll see if that's still true in this election, but the last two elections, it has been decided by evangelical Christians. And again, those are very different than the pagan interpretations of the English of what they called Christianity 300 years ago. So we'll see how does that affect the customs of the English system, of the legal system. And then I think probably most interestingly to me is you have a plurality. Now more people in the United States speak Spanish, either as a first language or a second language. And some, we live in New York, right? It could be a third language or a fourth or fifth language. And so how will that influence the legal traditions within the United States? It's very hard to tell. And then, you have a plurality of not white people, culture and customs. In other words, you can see in entertainment, you can see in, just parades in New York, you can see in commerce, right? You can see in what's bought and sold, non-English white male culture. And so how will that start to affect the legal systems? And the point being for this whole kind of, how do you think about which cultural customs should really be drawn on when you're trying to resolve a conflict among different types of people? Again, in 1776, it's a legal system designed by white Englishmen, for white Englishmen, and with white Englishmen. That is not the case in 2020, and certainly will not be the case in 2030 and 2050. So it's been a dominant system, right? The white Englishman, it has dominated the legal system, especially in culture, especially in beliefs, especially in processes and interpretations and customs through the common law. So should it continue to be dominant is one question. Should some other system dominate? Is the fact that it is a majority women in law schools now, right? So once it's a majority of women lawyers, should it be a more gender-based legal system? Or should it be a plural legal system? And Switzerland kind of has a process like that. South Africa also tries to have a process like that. In some ways succeeds, in some ways fails. So should it be a plural system? Meaning, should there be multiple interpretations of justice? And then should it be differentiated? Should it depend on your very particular group of people? If you're part of the Hasidic Jewish tradition, should you have your rules? If you're part of a Muslim tradition and you'd like to use rules from your religion, should that be applied? If you're an atheist, should you have your own special rules, right? And that's just thinking about religion. We could look at ethnicity, we could look at citizenship, we could look at a lot of different ways. So how should we really think about a legal system versus, what are the ideals that you'd find in a textbook when we all know that that's not even really happening?